The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. And today we're going to talk about the elements of a typical estate plan. So a lot of people know about wills and they've heard of powers of attorney and they've heard about trust, but most people don't know how it all fits together. And a lot of people don't know when people talk about estate planning, what are we talking about? So today we're going to talk about the basic documents that are in most people's estate plan and give a general sense of what they do and what their purpose is. So most people will come to me, say, I need a will, I just had kids, and a lot of times what they really need as the primary vehicle of their estate plan is a revocable living trust, maybe in addition to a will. Trusts are a big scary word. A lot of people think that these are expensive documents that only rich people need, but really most people that own their home have a trust as their primary estate planning vehicle, and that's because in Illinois, if you own any real estate outside of a trust or outside of joint ownership with right of survivorship, or if you own more than $100,000 of non-real estate assets outside of a trust or outside of a payable on death account, then your estate goes through an expensive probate case when you pass away. So it takes about a year. A lot of your assets are sucked up in attorney's fees and court costs, and your family doesn't have access to your assets until the conclusion of the probate case, which can take a long time. So we want to avoid that. One of the things that we want to do is create a trust, and that's basically a legal fiction that something other than you owns your property. It's a document that says, during my lifetime, I'm going to have complete control over the property, but when I pass away, so-and-so is going to be the trustee and responsible for distributing my property in the way that I want it distributed, and here's how I want it distributed. So it's an awful lot like a will in that sense. When you think of a will, you think of you're naming an executor to be in charge of your estate when you pass away, and you're saying how you want your property passed down. Well, a trust does all those same things, but it also basically holds title to your property during your lifetime. And during your lifetime, you don't notice the difference because you're going to be both the trustee and the beneficiary. Again, the trustee is the person responsible for managing the assets for the benefit of the beneficiary. So during your lifetime, you don't give up any control, but when you pass away, the assets that are held by the trust aren't part of your estate. They go kind of directly to the person that you want them to go to according to the terms of the trust. And what that means is that your estate doesn't have to go through probate if it's set up properly. And you avoid this year-long court case, and you avoid a bunch in attorney's fees. It can be 5 to 10% of the value of the estate sometimes in attorney's fees and court costs. So that's one big thing that we can accomplish with an estate plan is basically creating a trust, making sure your assets are held in trust. And, it's not just for rich people. It's for basically anyone who owns real estate. The other thing that a trust can do is if you have minor children, it can make sure that your assets aren't just dumped on their guardian and you hope that they spend the assets for the child's benefit, or that when the child turns 18, they don't just inherit everything all at once. A lot of people will say that I want my trustee to manage these assets for my child's benefit. When they turn 21, they can the kid can demand access to 1/3 of the assets. When they turn 25, they can get 2/3 of the assets, and when they turn 30, they can get everything else. During that period, the trustee has the power to give more than that to them. Whatever the trustee feels is necessary for their benefit and well-being, the trustee can give, but the trustee can say also, no, you don't have access to that. So basically, if the 21-year-old wants to buy a Lamborghini with all of his or her inheritance, the trustee can say no. If the 21-year-old wants to use it to pay for grad school, the trustee can say, yeah, I think that's a good use of the money. I'm going to cash out your trust account and give it to you. And then it's not until certain ages that the kid can get access to this. So the bottom line is that a trust gives a longer-term control from beyond the grave over how your kids or your beneficiaries are going to be taken care of, and it's not just an immediate distribution like a will. But a lot of times a will make sense for people. So there's basically two situations in which, well, one situation in which a will makes sense as a primary estate planning vehicle instead of a trust. And that is when you don't own any real estate and you don't have significant assets. You've got, you rent your property and your assets are way less than $100,000, or whatever is above $100,000 is in retirement accounts with a named beneficiary that's payable on death. So if you've got a small asset base, then a will makes perfect sense because your estate's not going to go through probate anyway. That's called a small estate, and it can be dealt with through a small estate affidavit immediately without the need for a probate case. So that's when a will makes sense instead of a trust. A will makes sense in addition to a trust in two situations. One is if you have minor children. The one thing that a will can do that a trust can't do is name a guardian for minor children, and that's often the most important thing in somebody's estate plan. So we want to make sure that your kids don't get all their money right away, or that you've got control over it over the long term without the assets being sucked up into a probate estate, and that's what a trust is for. And the trust will be the primary vehicle that lays out how everything's going to be passed down. If you've got minor children, the will be the place where you name who their guardians are going to be if you're not able to be their guardian. The second reason you might want to have a will in addition to a trust is if your wishes for what will happen to your assets differ significantly from state statute. A will, and we call this a pour-over will deal with any assets that do have to go through probate if for some reason something goes wrong from the time you set up your trust until the time you pass away. So let me game this out. Let's say we set up a trust for you and you do everything right. You transfer all your assets into it, but then you live for another 40 years and you get lazy about it and you acquire some real estate without putting it in the name of the trust, or you have a timeshare that you don't realize is real estate and should be in the trust, or you just let your checking account exceed $100,000. Well, in that case, whatever's actually owned by the trust is going to have to go through, or is not going to have to go through probate. It'll just pass immediately according to the terms of the trust. Whatever isn't owned by the trust will have to go through probate. So there's going to be this pool of assets that go through a probate court. The trust can't automatically control how those assets are passed down. In the absence of a will, state statute controls how those assets are passed down. So it'll be, spouse, children, grandchildren, then parents, and then siblings. And we have a whole video and article about how assets are passed down in the absence of a will or a trust. So you can check that out. But the bottom line is that you've got this pool of assets that aren't controlled by your trust. So what a pour-over will do, in addition to naming a guardian for minor children, will say that if probate is necessary, I have this trust in place, and I want my trust to control how all of my assets that have to go through probate are going to be passed down. So it's the mechanism that gives the trust control of any assets that might have to go through probate if something goes wrong. And that's only important if you don't want everything to be passed down according to state statute. So if you've got a nuclear family and you want everything to go to your kids and then grandkids, and you've got enough living kids that makes sense, then you don't really need a pour-over will unless your kids are minors, in which you'd use it to name the guardian. However, if you don't have a nuclear family, if there's a divorce involved or you're estranged from your children, and state statute would lead to a situation where the parent of your child who you're divorced from and you dislike is going to inherit all your property basically as the guardian of a minor child. If you don't have a will, then in that situation you would want to make sure that in addition to your trust, you have a will to just be extra sure that even if something goes wrong and part of your estate goes through probate, the person you don't want to inherit your assets doesn't inherit them, and that the people you want to inherit them do. This is also important for someone who wants a big chunk of their assets to go to the church or charity. Anything that differs from state statute. If you want to make sure that state statute doesn't apply to probatable assets, then that's when you would want a will in addition to a trust. So far we've talked about what happens when you pass away, and that is wills and trusts. And I think we've done a pretty good job of going through the details of that. We're going to speed things up here a little bit and next talk about what happens if you become mentally incompetent. And this is where powers of attorney and living wills come into play. So there's two types of powers of attorney. A healthcare power of attorney names someone to be responsible for your healthcare decisions and major life decisions that are non-financial if you're mentally incompetent to do so. A financial power of attorney names somebody to be responsible for financial and legal transactions on your behalf if you're mentally incompetent to do so through old age or accident or disease. If you don't have these in place before you become mentally incompetent, then whoever wants to manage your life for you is going to have to go and file a guardianship proceeding and be named your legal guardian, and then is going to have to annually file reports with the court on how they manage your assets. Problem is, this can be expensive, and stressful, and it can take a little while, just like probate. And they've got to get doctor's reports and expert witnesses and deal with a guardian ad litem, who's an attorney responsible for managing your best interests, and have a hearing before the court. And then they've got to appear in court and have an attorney help them prepare this report every year for the rest of your life. You don't want to, that's sucking up your assets that should be used for your care and putting a lot of stress on your family to deal with that. Guardianships are a great tool, but it's even better if you know who you want your guardian to be, to appoint them through a power of attorney ahead of time and make sure that a guardianship proceeding will never be necessary. And lastly, let's talk about living wills. This has nothing to do with what you normally think of when you think of a will. It isn't passing on anything when you pass away. It deals with if you are in a coma that's irreversible, there's 0% chance of you coming out of that coma. If you have a living will in your medical file, your doctor is instructed to terminate life support. And what this does is it takes the decision out of the hands of whoever you've named as your healthcare power of attorney, or out of the hands of your next of kin. And there's two reasons why people do this. Either they just really don't want to be left in an irreversible coma for physical reasons, or because they don't want to drain the family's finances. Or two, and more often, they don't want to put the emotional burden of pulling the plug on their kids or their loved ones. So if you have a living will in your medical file, you take that decision out of your loved one's hands, and you've already made the decision in advance. It's called an advance directive for that reason. There's no right answer about whether you should have a living will. Some of our clients do, some don't. It's a very personal decision, and there's some people want to keep the power in their loved one's hands to make those sorts of decisions. So anyway, a good estate plan, when we're not thinking about special concerns like special needs care or estate tax avoidance or creditor avoidance, a standard estate plan deal is basically a revocable living trust, possibly a pour-over will, a healthcare power of attorney, a financial power of attorney, and a living will. And if you have those documents, then you're basically in a good position financially if you pass away, to make sure everything goes smoothly to your children, that a guardian is named for your child, and that if you become mentally incompetent, someone's set up to care for you without using a bunch of your assets to be named as your guardian, and that your end-of-life decisions are made in advance. So if you have any questions, please leave them in our comments section. Please subscribe on YouTube, iTunes, SoundCloud, and anywhere else you can find this podcast. And feel free to give us a call for a free consultation at 630-324-6666. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.
Do you have too much stuff? Is your dorm, apartment, or house too full and you don't want to sell, give away, or throw out anything? If so, Hobson Storage can help. We have over 10 different sized units to meet your needs. Our climate-controlled units are safe, secure, and conveniently located within the western suburbs. Call us now at 630-964-4047 to find out how you can get 15% off an upper-level unit, 2 months of free rent, or use of our van to help you move in. Call us and use promo code A1V as in Victor to take back control of your space with Hobson Storage.